Hi there, I'm Jenna Layden, the Vice President of Legislation for San Diego SHRM, and I'm back with another legal update. Don't forget to check back every month, as I'll be bringing you the most current information you need to know in order to be up to date on the legal issues that are affecting California's employers. Let's start out with this month's legislation update. Governor Brown has signed into law AB 1844, which prohibits employers from requiring or requesting that an employee or applicant for employment, number one, disclose a username or password for the purpose of accessing personal social media, two, access personal social media in the presence of the employer, or three, divulge any personal social media use. The bill also prohibits an employer from discharging, disciplining, threatening to discharge or discipline, or otherwise retaliating against an employee or applicant for not complying with a request or demand by the employer that violates the new law. Notably, the bill does not affect an employer's existing rights and obligations to request that an employee divulge personal social media reasonably believed to be relevant to an investigation of allegations of employee misconduct or employee violations of applicable laws and regulations, provided that the social media is used solely for purposes of that investigation or a related proceeding. Additionally, the bill does not preclude an employer from requiring or requesting that an employee disclose a username, password, or other method for the purpose of accessing an employer-issued electronic device. In other legislative news, Governor Brown has signed AB 1964, which includes a religious dress practice or religious grooming practice as a belief or observance covered by the Fair Employment and Housing Act's protection against religious discrimination, and specifies that an accommodation of an individual's religious dress or religious grooming practice that would require that person to be segregated from the public or other employees is not a reasonable accommodation. The bill also clarifies that undue hardship, as defined in the Fair Employment and Housing Act, will apply to the religious discrimination section of the statute, thereby clearing up confusion over federal versus state definitions of undue hardship. Under the FEHA, undue hardship means an action requiring significant difficulty or expense when considered in light of the following factors. Number one, the nature and cost of the accommodation needed. Number two, the overall financial resources of the facilities involved in the provision of the reasonable accommodation, including the number of persons employed at the facility and the impact the accommodation would have on the operations of the facility. Number three, the overall size and financial resources of the covered entity. Number four, the type of operations at issue. And number five, the geographic separateness, administrative, or fiscal relationship of the facility or facilities. Moving on to our judicial update for this month. In Lamps Plus overtime cases, the California Court of Appeal upheld a trial court order denying class certification based in part on guidance provided by Brinker. The plaintiffs in this case, who are former and current employees of Lamps Plus, filed a class action lawsuit against Lamps Plus alleging that the company denied them meal and rest breaks, required them to work off the clock, failed to provide them itemized wages statements, and failed to timely pay wages due upon termination. The plaintiffs moved for class certification, but the trial court denied the motion on the ground that the individual issues predominated over common issues as to the various claims, and therefore class treatment was not superior to individual actions. The trial court reasoned, with respect to meal and rest breaks, that pursuant to the California Supreme Court's ruling in Brinker, employers need only authorize and permit breaks, in other words, make them available, but do not need to ensure that they are taken. The trial court also concluded that commonality had not been established for the remaining claims, as they all required individualized assessment, and there was no evidence of any illegal company-wide policy. In affirming the trial court's order, the Court of Appeal noted that pre-certification discovery had revealed the following things. Lamps Plus did not have a universal practice of denying employees their breaks. Lamps Plus had a meal and rest period policy which conformed to law. Number three, Lamps Plus disciplined its employees for failing to comply with the policy. The breadth of the supposed violations was widely variable. Some employees declared that they often missed meal and rest breaks, while others declared that they always received their meal and rest breaks, and still others declared that they always received either their meal break or their rest breaks, but not both. Some employees declared their meal breaks were uninterrupted, and others claimed interruption of varying degrees. And approximately half of the employees surveyed said LAMS Plus required them to work off the clock, while the other half reported no off-the-clock work. The court also found that there was no evidence that LAMS Plus knew of any off-the-clock work. The employees reported varied experiences with respect to their pay upon termination, and even the named plaintiffs had divergent experiences despite having all worked at the same store and reporting to the same manager. In light of the fact that there were so many divergent experiences and LAMS Plus had compliant policies and was not obligated to ensure employee compliance with meal and rest break policies, the appellate court agreed that the case was not suitable for class treatment, as the trial court would have had to conduct many inquiries into employees' individual circumstances. And finally, in Reyes v. Lieberman Broadcasting, the California Court of Appeal reversed the trial court's order denying the defendant's motion to compel arbitration, finding that the arbitration agreement at issue was enforceable despite the fact that it did not contain an express class waiver. The plaintiff, Jesus Reyes, filed a class complaint alleging wage and hour violations against Lieberman Broadcasting. Reyes had previously executed an agreement to arbitrate his claims with Lieberman prior to commencing his employment. The arbitration agreement was expressly governed by the Federal Arbitration Act and provided that Lieberman and Reyes agreed to submit to final and binding arbitration all claims, disputes, and controversies arising out of, relating to, or in any way associated with Reyes' employment or its termination. The agreement did not contain an express class arbitration waiver. In reversing the trial court's denial of Lieberman's motion to compel arbitration, the appellate court held that although the agreement did not include an express class waiver, such a waiver had to be because of AT&T Mobility versus Concepcion, a prior United States Supreme Court decision making clear that class claims cannot be compelled to arbitration unless the parties to the agreement expressly agree to arbitrate class claims. The court noted the conflict among California state and federal courts as to whether AT&T Mobility preempts California's previous tests set forth in Gentry v. Superior Court for determining whether a class waiver in an employment arbitration agreement is enforceable. The California Supreme Court previously held in Gentry that a court may invalidate a class action waiver and require class arbitration if it determines that individual arbitration is impractical as a means of vindicating employees' rights. The court then set forth various factors to be used in determining that the matter should proceed as a class action. However, the court in the current Reyes case held that the plaintiff had not made any showing as to why the agreement at issue would fail under Gentry, even if Gentry is still considered good law. As such, the court held that it did not need to decide whether Gentry is still good law. The court held that under Gentry and AT&T Mobility, the agreement was enforceable. While the case law regarding class action waivers is ever-changing in California, this case is a positive ruling for employers. However, employers may wish to review their current arbitration agreements and add express language regarding class arbitrations. For more information on these and other hot legal topics, check out San Diego SHRM's newsletter, The Resource, at www.sdshRM.org. Additionally, I invite all of you to join San Diego SHRM's Legislation Committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please contact me at 858-509-5696. You can also contact me via email at jleyton, that's JLEYTON, at pettitcohn.com, PETTITKOHN.com. That's all for this month's legal update. I'll be back next month with more of the information that you need to know.